Chapter 3, Legal Issues, Part 2. In this particular PowerPoint, we're going to cover what might be the most difficult and complicated topic that we'll cover throughout the entire course. We're going to cover the notion of incorporation. I'm going to try and keep it pretty basic because incorporation is such a complicated topic, and if you're really interested in learning more about it, I suggest you go to law school because you'll certainly get a healthy dose of it. But for us, we're going to try and keep to some of the basics. Incorporation essentially deals with the 14th Amendment and the Bill of Rights. We'll get to the 14th Amendment in a couple slides, but the question is, do the Bill of Rights, or I should say, does the Bill of Rights apply to the states through the 14th Amendment? If you're confused about that, hopefully you won't be after a few slides. So again, let's keep to some of the basics. So the Bill of Rights, as we said in our last PowerPoint discussion, was ratified in 1791, and so we want to cover the period of 1791 to 1868. You'll see in just the next slide why 1868 is important. 1791 is when the Bill of Rights is ratified, becomes the law of the land, and 1868 we'll see is when the 14th Amendment is ratified. But we'll get to that in just a little bit. So the first question when we ask about the Bill of Rights, and we haven't studied them, we haven't gone into the individual rights that are contained in them. They contain things like freedom of speech, freedom of the press, freedom of religion, but also a lot of criminal procedural rights like protection against unreasonable searches and seizures, right to an attorney, right to remain silent, right to trial, protection against cruel and unusual punishment, and so on and so forth. Well, the question is, we have all these great rights, but which particular government, federal and or state, is required to obey them? Now, do they apply to private citizens directly? The answer is no. If your mother or father tells you to shut up, you can't say, they've deprived me of my right to freedom of speech, unless they happen to be acting as a police officer at the time or as a prosecutor or whatever. But assuming that your mother or father is not acting in that capacity, they're just acting as a mother or father, the Bill of Rights does not apply to them. It only applies to government action. But again, which government? So in terms of federal action, this is going to be the easiest part of our lecture, because anytime the federal government acts, no matter who it is, whether it's a law enforcement officer or the president or whoever, when the federal government acts, it must obey all provisions of the Bill of Rights, because the Bill of Rights is part of the United States Constitution, the federal Constitution. So therefore, every single provision in all 10 amendments to the Constitution do apply to federal action. So again, that means the federal government must obey all provisions of the Bill of Rights. But the tricky part for us, and what makes this lecture so difficult and incorporation so difficult, is, well, what about state action? Well, early on in the early 1800s, there was a court case in which the U.S. Supreme Court held that state government action is not bound and restricted by the Federal Bill of Rights. So what that means is, from 1791 until at least 1868, state governments did not have to obey any of the Federal Bill of Rights. It was as if the Federal Bill of Rights were the laws of another country. So think of it today. If in Germany they change their constitution, do we have to obey it here in the United States? The answer is no, because Germany is a different country, a different set of laws. Well, the same kind of thing was happening under our federalism, notion of federalism for government, in which during this time period, at least 1791 to 1868, state governments did not have to obey any of the Federal Bill of Rights. They only had to obey their own state constitutional law. So what did this mean in practice? Well, let's assume that it's 1845. Okay, so after police departments are now more common in the United States. Remember, we said the first police department was in London in 1829. So let's say it's 1845. So notice that the Bill of Rights was established before the first police department. But let's assume that it's 1845 and the Philadelphia police exist. So if a Philadelphia police officer would unlawfully break into your house and search it, find evidence of criminal wrongdoing, and arrest you, and if you said, I think this is wrong, I think the police officer violated my protection against unreasonable searches and seizures under the Fourth Amendment of the Bill of Rights, the Federal Bill of Rights, well, if you argued that and you took your case to federal courts and said, that Philadelphia police officer who is a state actor, and what we mean by state is anyone who isn't a federal actor, so it can be any level of state government. It can be city, county, state, any level of government. But a Philadelphia police officer is definitely a state actor, so they're not a federal law enforcement agent. But if you went into a court and said in 1845, that Philadelphia police officer violated my Fourth Amendment federal rights, the court wouldn't even hear your case. They would say, why are you here? Again, it would be like saying, the German police did something to me in Germany, so here I am now in United States courts arguing that the German police acted unconstitutionally. The American courts would look at you and say, why are you arguing here? Go to Germany. Go argue there. Well, a similar kind of thing would happen in 1845. The federal courts would say, why are you even here? The Bill of Rights does not apply to the Philadelphia police. You think the police officer did something wrong? Go into the Pennsylvania courts and argue there. So 1791 to 1868, for the federal government, they have to obey all of the Bill of Rights. For states, they don't have to obey any. But in 1868, we have the 14th Amendment to the U.S. Constitution. It's passed after the end of the Civil War, and it's really meant to ensure the constitutionality of some civil rights laws that were passed at the end of the Civil War. But it contains an important provision, what we call the Due Process Clause. And that clause says that no state shall deprive any person of life, liberty, or property without due process of law. So a state can take away your life, it can take away your liberty, your freedom, it can take away your property, but it must provide you with due process. Now, what does that mean? Well, that's what we're going to figure out during this particular chapter, at least a little bit of it. But in general, it means the state has to comply with the rules of criminal procedure before they can take away your life, liberty, or property, if we're talking about a criminal case. It can also apply to civil cases as well, but we're only concerned about criminal. So here is an amendment that now is part of our U.S. Constitution that specifically says no state shall do something. So now it appears to at least open the doors a little bit, if not a lot, to the federal courts. Because now it seems to be saying, okay, federal courts, you can now take a look at state proceedings, whether we're talking about trials or punishments or police actions. You can take a look at them now under the 14th Amendment, because you can determine if the state government, in whatever form that it was acting, whether it's a police officer, a court, or whatever, did they deprive a person of life, liberty, property without due process of law. But the amendment doesn't tell us anything more. It doesn't tell us what are the liberties that are protected. It doesn't tell us what due process means. So how did the courts react? Well, they said that liberty, well, we're going to have to figure it out basically over the course of time. But initially, at least, when they were trying to interpret liberty and due process, so I have question marks beside these because what are they? What are liberty? What is due process? We need to know the meaning of these terms if we're going to interpret the 14th Amendment and apply it. Well, what the states did for the next several decades is they basically took, the U.S. Supreme Court specifically, took a hands-off approach as it applied to the states. So what can we say about the Federal Bill of Rights in this period, from 1868 to roughly the 1930s? Well, as we said before, and we'll say always, the federal government must obey all provisions of the Bill of Rights. That's the simple part of the incorporation story. But state action, what about it, now that we have a 14th Amendment? Well, it was as if the U.S. Supreme Court pretended the Civil War didn't exist, there wasn't a major upheaval, and it really took a hands-off approach. And what we mean by that is, during this time period, it generally let the states do what they wanted. It didn't really look over their shoulders to see what are they doing in their courts, what are they doing in their police departments, in their headquarters. Are they beating confessions out of people? Are they doing other kinds of things that would violate the Federal Bill of Rights? So even though the 14th Amendment might seem that it would open the door to these kinds of inquiries, that didn't happen. Okay. Instead, what happened was the federal courts took hands-off approach, and in essence, the state government still didn't have to obey the specific provisions of the Federal Bill of Rights. Now, this gradually changed. This hands-off doctrine was becoming weaker as we got to the 1930s, so it's not a bright line period that as soon as we hit 1930, the Supreme Court started changing its mind. Now, gradually, the court started thinking more and more in terms of we need to make the states more accountable. We need to have a more uniform system of justice. But it wasn't there yet in the period from 1868 to the 1930s. In the 1930s, we have some significant developments. Federal action, same old story. The federal government must obey all provisions of the Federal Bill of Rights. But in state action, the U.S. Supreme Court began to apply the 14th Amendment's protections on a case-by-case basis. So what they would do is, as these cases started to come out of especially out of the South, and oftentimes they involved racism. And I mean, some of these were terrible violations. There was a case involving a sheriff who took a black suspect out and hung him to the point of death and kept asking him if he wanted to confess. And finally, after several hangings and almost dying, the guy confessed, and they convicted him on the basis of this. Well, the Supreme Court said those kinds of practices shocked the conscience. And so they applied the 14th Amendment generally. They didn't say, well, and it's shocking because it violates the 5th Amendment's protection against self-incrimination. You can't hang someone to force them to talk. They didn't say that. If this had been federal actors who had hanged the man, then yes, they could have applied the 5th Amendment directly. But instead they're saying, let's look at each case and see if it's shocking. Are they really doing something shocking in the South? Well, as I said, they didn't rely on specific clauses to do this. They just asked on a case-by-case basis, is this shocking? Lawyers don't like that kind of reasoning. They want something more certain. So you heard a louder and louder call beginning even earlier than I have here, the 1940s, but actually it was even earlier, to say, why don't we start saying that specific provisions of the Bill of Rights also now are binding on the states. So federal action, once again, in this time period from the 1940s to the present, federal government must obey all provisions of the Federal Bill of Rights. But state action, as I said, the lawyers wanted to get rid of the shocks the conscience standard and said, why don't we just start saying, hey, the First Amendment freedom of speech, it applies to the states. It's one of the liberties that is part of the Due Process Clause of the 14th Amendment. Protection against unreasonable searches and seizures, it's one of the liberties that's protected. All these kinds of things. They started calling for incorporation. What we mean by incorporation is almost like making a hyperlink. If you could click on the word liberty in the 14th Amendment or even due process, it would take you to specific provisions of the Bill of Rights so that we would know what it would mean, and then all the law for those provisions would apply as well. So incorporation gradually over the course from the 1940s, even till recently, we just recently incorporated the Second Amendment, specific provisions became part of the meaning of the 14th Amendment's liberty or due process clause. So what that meant was, as we see here, beginning in the 1930s, for some rights like freedom of speech, freedom of religion, then 1940s for criminal procedure rights, the court decided which rights were in, which rights were not. Almost all of them were incorporated. They never incorporated all of them. So we've never had total incorporation. The total Bill of Rights do not apply completely to the states, but they almost do. The Sixth Amendment's grand jury requirement is an example of one that hasn't been required. So the federal government must have a grand jury proceeding before they proceed to trial, before they can bring charges. The charges are brought after a grand jury. In states, we don't have to. So states must obey all incorporated rights, but not all the rights are incorporated. So today, the effect is that incorporated rights apply equally to both federal and state action. So almost all the Bill of Rights now do apply to both state and federal government.